I'm a big believer in second chances, even for people who commit serious crimes. Who deserves a second chance? Who gets one? And who decides? I'm Jessica Henry, and I'll be your host of Just Justice. I'm a former public defender, a professor of justice studies, and an award-winning author. And I'm excited for us to find new ways to put justice back into our criminal legal system. Hello, and welcome to Just Justice. My name is Jessica Henry, and I'll be your host. Today we have the pleasure of speaking with Professor Steve Zeidman, who's the co-director of the Second Look Project Beyond Guilt and the Defenders Clinic at CUNY School of Law. A graduate of Duke University School of Law, Steve is a former staff attorney and supervisor at the Legal Aid Society. He has taught at Fordham, Pace, and NYU, and has received numerous awards for his excellence in teaching. Professor Zeidman is a member of the Appellate Division's Indigent Defense Oversight Committee and the American Bar Association's Criminal Justice Section Council, and he serves on the board of directors of Prisoners Legal Services and the Parole Preparation Project. Welcome to the show, Steve.
Glad to be with you, Jessica. Thank you for the invitation.
Oh my gosh, it's my pleasure. And one of the things Steve and I were just talking about before we started is that Steve was actually on the faculty when I was a student at NYU Law, and he was much beloved. And so it's so great to have this full circle moment where I get a chance to really explore some of the things you've done and that you're working on in your career today. So one of the things I'm wondering, just big picture here, Steve, you've devoted your whole life, really your whole life, to working on behalf of people who've been accused of crimes or convicted of crimes, poor people, people who have experienced the injustices of the system. And I'm just wondering if you could start us out by talking about what drew you to the work of second chances in the first place.
Second chances in the first place. I like that. I have to confess that it was fortuitous, because the focus of my career had been on the front end, representing people who were arrested and doing trial work, and maybe every now and then a direct appellate issue. But it was really sort of cabined in the traditional public defender way, which was trial work. And it was 2015, I received an email, and this happens all the time. If you're a criminal law professor at a law school in New York, you just get these letters. And this one referred to a woman named Judy Clark, and it said she was doing 75 years to life. And there was a solo practitioner saying, I've been trying to figure out a way to extricate her from this death by incarceration sentence. And I've been doing it for years. I'm getting nowhere. Maybe someone would like to help out. And I remember Judy's case. It's sort of a high-profile case from 1981, a Brinks robbery. Several people, including 2 police officers, were killed. So I remembered it. But more than that, I couldn't believe she was still incarcerated, because this was going on 35 years. So I wrote back and said, look, I'll give it a shot if nobody else steps up. And that was the response I got. Nobody else. So Tag, you're it. And that's what really started me down the path of, is there any way to revisit a long sentence? Are people just consigned to die in prison?
So what happened in Judy Clark's case?
I did what everybody does, right? Especially as a lawyer. I said, okay, she's serving 75 to life. I knew from this other lawyer that she had all sorts of support from people inside and outside, the superintendent, correction. I mean, you name it. She'd done everything. Remorseful, had done everything possible to atone. So my first step was, I figured I would go into court. I would file a motion for resentencing, saying maybe it made sense to you or whoever the judge was 35 years ago to give her 75 to life, but we now see she's a different person. I always say this because it's both a little humbling and embarrassing, but I think it's an important message to get out there. I didn't realize when I set about filing a motion that there was no such motion to file. New York has a resentencing motion, but only if you can show that the sentence is illegal. So there was no interest of justice provision, no way to get back into court. So that led me to begin to seek alternative pathways to freedom, if any existed.
Yeah, I think that's something people don't know. We think, okay, if you can just find the right case, there's a vehicle to get them out. And it's really not true. The law preserves convictions and sentences. It's designed to protect and keep things final. We don't want people to have a chance to revisit their terms, and it can create huge injustices. But you're right, people don't know that. So there you were. You realized, oh my goodness, I can't help right now. So what did happen? I'm actually really curious.
Well, I began to think, are there other potential ways? I mean, first of all, I did try and pursue the resentencing in court, looking at the statute, looking at other states, realizing that New York, it's just an omission. And I'm sure we'll talk about how to try and fix that legislatively. But realizing that that was probably a dead end, the only other option available was clemency from the governor. So I began to look into what was then Governor Cuomo's clemency power. Where did it exist? How vast and extensive was it? Had it ever been used? And in many ways, it was similar to the resentencing problem because everybody said this is never going to happen. It turned out when I looked at it, Cuomo had been the governor for 4 years. Not a single person had their sentence commuted. And when I began to look nationally to see if I could shame the governor, I began to realize that very few governors who have this power actually use it to commute sentences. But at least it was possible. So I figured, let me try and put together some sort of a clemency application and get something in front of the governor. Well, here's the ultimate lesson for me. There's Judy's case, but then there's the ultimate lesson. So just like with the resentencing motion, doing what most lawyers would do, in this situation with clemency, I did what all of us do whenever we're doing something new, is I turn to people who've done it. I reached out everywhere to say, hey, have you ever filed a clemency application? No. Have you ever filed a clemency application? No. Speak to this organization and that individual. No one had it, which again made me realize this is an underutilized process. Unlike the motion in court, one could argue you can't file. There's no relief. A judge will dismiss it out of hand. The worst that can happen is you file something with the governor and you get denied or you get ignored. So I spent a good year gathering material, building on what the prior lawyer, a woman named Sarah Bennett, had put together, letters of support, again, from people inside, outside, a reentry plan, the so-called institutional record, Judy's own personal statement to submit to the governor's people in the hopes that this might open the door a little bit, not just for Judy, but for everybody. And fast forward to an awful lot of work and effort, and I was certainly not alone, but ultimately Governor Cuomo then did grant her clemency and commuted her sentence to make her eligible for parole. Not the first time. That's the other part of it. The governor's power in New York, it's right there in the state constitution. It's pretty remarkable because it's not a bill, it's not a law, it's not an executive decision. It is right there in the New York State Constitution that the governor has really total power to commute a sentence. And I think it's important. Let me just mention this because people hear the word clemency. It's an umbrella term. So there's clemency, meaning we can pardon somebody. There's clemency, meaning we can commute a sentence. And a pardon just wipes out, expunges your conviction. Whereas commuting a sentence does exactly what it sounds like. It reduces the sentence. And what was interesting to me, it's still interesting to me, when I say this in class or when I say this to a group of people, I say, which do you think is more controversial, more rare? Everybody says a pardon because that expunges the conviction. And I said, well, that makes sense, but actually it's commuting a sentence is much more controversial because the pardons are almost always given to people who are out of prison. So the standard case over the last 15 years in New York is a pardon to someone who has, say, a marijuana conviction from 20 years ago and now is facing deportation or now can't get a certain license because of that old conviction. Much less controversial. So the commutation piece, trying to persuade a governor to commute a sentence, it's a political lift. And what I think happened with Judy and what has happened with several people I've worked with since is governors saying, look, I'm going to go halfway. I'm going to reduce the sentence, but not to say you go home tomorrow. Well, you've been in 34 years. Your new sentence is 34 years, go home. I'm going to give you an indeterminate sentence, 34 to life, which means you get to see the parole board. And the ultimate decision is on them. So I don't have to, as a governor, I don't have to take the whole weight. I have to say on this, when I got the phone call from the governor's office that Judy was being granted clemency, they actually said to me, and I have all these notes from that incredible day, they said, look, we have good news. We think you're going to think it's good. We don't know if you're going to think it's great. I said, all right. So the good news is she's getting clemency. She's getting a commutation. And my first thought was, why isn't that great? And they said, well, the governor is not releasing her immediately. So she's going to have to go to the parole board. And of course, that happened about 4 months later, she was denied parole, which is mind blowing. The first person to get clemency in who knows how long. The board denied parole. She came back in 2 years and was finally released and has been doing good and doing well ever since.
Yeah, that's an amazing story. And it actually really illustrates so many of the things I hope we'll get to talk about today, and also just the landscape. I mean, that's what's happening right now for listeners who are sort of keeping abreast of current events. With the Menendez brothers, there's been talk that they're going to be resentenced to a sentence that allows for parole. And then the parole board will have the ultimate decision. And of course, the irony, and we'll perhaps get there, is that parole boards are appointed by the governor. So it's one and the same ultimately, but it's very interesting.
Yeah. So many people said to me when Judy got clemency, they said, yo, the parole board's going to be a shoo-in. The governor appoints the members. You really don't have to do anything. I didn't take that advice. I didn't believe it. And in fact, unfortunately, my concerns were borne out. The odd thing about it, and I'm sure we'll get to talk about this, the clemency applications in New York, I cannot overstate this, that they are vetted. They are reviewed. I mean, everybody I know who's received clemency, that application was pending for a year, 2 years. And you get phone calls from the governor's staff saying, what about this ticket that they got in prison from 1988? What about this misdemeanor conviction from 37 years ago? Your client says in the personal statement XYZ, but we thought it was ABC. I mean, so the irony about that. And by the way, I should say, I respect that, right? This is a heavy decision. But then you go to the parole board, which spends half an hour looking at somebody's, and the idea that they think, well, no, we're not giving you parole. It was kind of a sham.
And it's deeply disappointing because you feel like all the vetting that had been done was sort of for naught. Yeah, it's very frustrating. Now, Steve, you started in light of this. So Judy Clark sort of rolls your way and you take this opportunity to think about second chances and the mechanisms or lack thereof of mechanisms for relief. And you started at CUNY a Second Look project. And part of the name of the Second Look project is Beyond Guilt. And I love that idea. And I'm wondering if you could just tell us a little bit, what do you mean when you say Beyond Guilt?
Sure. When I began to do the work, and I would speak to people about it, people in the media, elected officials, community organizers, community associations, it was interesting to me how quickly everybody would say, oh, sure, I know exactly what you mean. There's this person who I know is innocent. There's this other person who you should speak to. They didn't do the crime. And I realized, and this has always been an issue, I think, for a lot of people who were formerly public defenders. Obviously, innocent people being convicted, there's no word to describe it. It's horrific, but it obscures the larger problem from my perspective. It's the unintended consequence of the focus on innocence. To me, the larger problem with the criminal legal system is the hyper-punishment, is the massive sentences. And so that's what we were trying to capture with the title Beyond Guilt, which is, Judy Clark didn't say I was innocent. The overwhelming majority of 170 people I've worked with have not said I'm innocent. They said, I did this. Let me explain why. I'm not making excuses or justifications, but I'm hoping you can see that I'm not the same person and give me an opportunity to live life on the outside. And so that's always been the message that I've been trying. It's so hard to get traction because everybody understandably zeroes in on innocence. Every time I talk about someone who got clemency, especially the lawyers, they'll say, oh yeah, I had this guy once who didn't do it. I said, yeah, no, I know that. But for me, and Jessica, I'll just say this because I feel like to me, it's becoming my own cliche. Like we understand everybody. I say we, I think left and right, conservative, liberal. There's now a recognition about mass incarceration, that there's a crisis of mass incarceration. But what I think gets missed is one of the primary drivers. And we can talk about the war on drugs, tough on crime, institutional racism. That's certainly all of it. But to me, it ends up being played out in the massive sentences that drive this, that they fuel mass incarceration. There are sentences that are doled out unlike any other democracy, industrialized nation. I mean, in New York City, right? We have blue New York State, very blue New York City. This week, I am sure there was somebody who was sentenced to 50 to life for something they did when they were 18. And so we have about 7,500 people serving those kind of sentences in New York alone. It's just a matter of saying it's not about innocence. It's a matter of saying, do they have to die inside?
Yeah. So you're saying there's about 7,500 people serving life sentences or extremely long sentences in the state of New York?
Correct.
Yeah. And one of the things people don't think about, I mean, that's a 7,500 people and change who are likely to die in prison or at least grow very, very, very old in prison. And I'm wondering, Steve, if you can talk a little bit about some of the issues that come up with this increasingly aging population in prison.
Sure. One of the really interesting and important discoveries from doing the clemency work. So I should just back up a bit. In the course of doing Judy's case, a couple of things happened. I wrote an op-ed or two. I began to take on a couple more cases with students. And the reason I'm mentioning that is the students then, we were just fanning out into prisons across New York State. And so word spread. And so letters began to pour in. Last year, we had 878 requests for help. This year, it's going to be over 1,000. Remember, you think 7,500 people, right? People saying, hey, I got 50 to life when I was 18. I got 75 to life when I was 25. I got 40 years when I was 30. The numbers are incredible. So what began to happen is our focus on clemency, inevitably, a lot of the people who wrote were older. They had served 35, 40 years. They were familiar with Judy's case. It was amazing to me the impact that had. They said, I never dreamed of clemency given the nature of the case I was convicted of, a homicide. And I should say, most of the people I've worked with have been convicted of very serious crimes. But like Judy Clark, I've been in 35 years. Like her, I've done a lot to change and atone and do everything I could to repair. So we would gather their institutional records. And the aging piece comes into play, not just by saying they've been punished. They've done 30, 35 years, but so many people had serious medical issues, which then naturally made me look at, well, does New York have any version of compassionate release? And New York does. It's called medical parole, but like clemency, it was virtually never used. So we began to try and crack that door open. And you can imagine, when you talk to people about this, about people dying in prison, some people it tugs at their heartstrings, their humanity. Other people talk about cost.
I mean, both are legitimate, right? Because one, the idea that folks are dying in prison, right? Again, people love this idea or don't think too much about this idea of a life sentence for someone who commits a murder. Oh, yeah, they should be sentenced to life. Well, when you really play that out, that means that someone's going to die in prison. They're going to grow old in prison. They're going to get sick in prison. People in prison suffer the same illnesses as the elderly do on the outside, but perhaps worse because the care isn't there. And then who pays for that? Well, that's the taxpayers. That's tax dollars that aren't going to your children for their education or to your public services or whatever you might want your dollars to be spent on, spent for healthcare for the aging prison population. And then there's a question of human dignity, which doesn't just pull on your heartstrings, but has to do with, I think, a moral compass, right? I mean, but Steve, you got your fingers in basically everything. And so let's just go back to what you said with Judy Clark. You said you tried to go into court and you realized there's no mechanism. So one of the things that your Beyond Guilt clinic does is you use underutilized procedures to help people who've been incarcerated for a long time to try to find an avenue to gain release. Can you tell us how that works in practice?
Sure. The way I think about it, clemency is a gubernatorial power. Resentencing motions are a judicial power. Parole is an administrative agency's power. And trying to think, how do we open the door, multiple pathways to try and extricate someone? Because it is real hard once a sentence is imposed and the direct appeals are finished to extricate somebody. So the resentencing piece, which I had abandoned early on,
because there wasn't a mechanism, as you were saying.
And then we thought, myself, the students, my colleagues, we thought, okay, if the issue that we have to address is whether the sentence was illegal, what are the potential arguments that we can make that the sentence was illegal? And one of the first places we went to has to do with Roper, Graham, Miller, Montgomery, the Supreme Court rethinking life and long-term sentences for young people. So there were a number of people who fit squarely within that, who were 17 or under. And as you know, the Supreme Court drew this artificial line at 17. But we then tried to push the envelope. So I'm thinking one person in particular, was 18 in 3 months, got 50 to life, has been in 35 years. So we were trying to argue in court that the sentence is illegal. He should be resentenced because under the New York State Constitution, we think we're going to take Supreme Court case law and extend the age past 17, that there's an Eighth Amendment cruel and unusual violation. So we've tried that in a number of counties across the state. Similarly, as I began to do the clemency work, and the clemency work, it's not just about getting the institutional record. The reason I think it takes at least a year to do a really robust clemency application is I believe you have to get the trial transcript, all court records, because one of the things I was noticing over and over is I would read the sentencing, and we've now spent a year with our clients. We've interviewed family members. We do psychosocial reports. We get records from when they were in elementary school. And no surprise, we uncover all sorts of abuse and trauma. And then you go back to their trial and you see what their trial lawyer did at sentencing. And in a nutshell, it was nothing. They spoke for 2 pages, say, hey, judge, my client denies guilt and has a solid family behind him, and I hope you'll give him a lenient sentence. So we thought, okay, now we have a Sixth Amendment violation, ineffective assistance of counsel at sentencing. So this is just for us, it's a wedge issue. The first motions that I filed were basically to set in the interest of justice, judges say, get out of here. There's no such provision. But now I'm playing in your sandbox. I'm saying, wait a minute, I have a legal basis. You might disagree with me. But what's happened then, once we get in court, now we can try and work with the prosecutors and say, don't oppose this motion. This is the right thing to do. And slowly but surely, we're getting some buy-in, not enough. I mean, I could go on and on about my frustrations with prosecutors unwilling to re-examine a sentence, but I really have to give respect to the Kings County District Attorney. That office, Eric Gonzalez, has a unit, a post-conviction justice unit, which is designed for exactly this purpose. And the lawyers there in that program want to know, is the sentence still just, necessary, and appropriate? Give us a hook. You think there's a legal basis? All right, maybe we don't necessarily agree with you 100%, but you know what? We're not going to oppose the motion because we think 35 years for this person is enough. I wish I could say we've had as much success across the state. We're not there yet, but we're still banging on the door.
So the resentencing that's going into court, and there are some other ways to get into court now, right? There was a 2019 Domestic Violence Survivors Act, or Domestic Survivors Act, and that provides an avenue to get into court, right? It provides a second chance, possibly, for people. Have you had any success with that? Have you worked with that? What's happening?
We have worked with that. No surprise. It's a remarkable statute. To me, it paves the way for a resentencing statute more broadly defined so that we're not just focused on one incredibly deserving class. My colleague and friend, Kate Mogilescu at Brooklyn Law School, is the person who has led the charge to get that bill passed, to represent people who are seeking to be resentenced, who can show that there was really unrecognized or undervalued evidence of domestic violence, trauma, and abuse in someone's background, to get into court and resentence. The problem is, and this is no surprise, most judges throughout the state, I think, are taking a really sort of a myopic view of the statute, trying to say exactly, show me the abuse. You have to prove it. Did you call the police? Did you go to the hospital? And we know, right? Anybody who's worked with people who've been victims of domestic violence know the challenges with that. So there are hurdles, but to me, it's a wedge issue. It's opened the door a bit. It's just a matter of everybody driving through it.
So you've come up with sort of a Sixth Amendment challenge, an Eighth Amendment challenge. There is this new law that's narrowly applied, but does give you some access to the courts. And then there's also a second look law that's been at least kind of percolating in New York. Can you tell me a little bit about that, what your experience is, what's happening?
Sure. Yeah, the second look bill is long overdue. It addresses that lack of an interest of justice provision. This has been my recognition, and this is the way I try and deal with elected officials to try and get them on board. And there is a bill that has a fair amount of support. There's an organization called Communities Not Cages that is really leading the charge, advocating in Albany, gathering a lot of support from elected officials. But here's the irony. In New York State, when someone is arrested, regardless what they're charged with, It could be the most serious to the most minor. You can move to dismiss the charges in the interest of justice. That's the phrase. Similarly, when someone is convicted, and it can be of any charge, it can be of a murder, when they are convicted and sentenced on appeal, they can seek to have the sentence reduced in the interest of justice. Yet 20, 30 years later, when someone has had the opportunity to show that they're a different person, there's no interest of justice provision in the resentencing statute. It seems to me to be just a glaring omission. So that's really what the bill says. It says that anybody, if you've served 10 years, you are automatically entitled to judicial review of your sentence. You're not automatically entitled to a resentence, but you are entitled to a review of your sentence to see, this is my favorite line, to see if it remains just, necessary, and appropriate. And if a judge determines that, you haven't done all your programs, you're getting in fights, what have you, original sentence stays. So be it. You can appeal it and take another shot later, but at least to give people the chance. And, I want to mention one thing. When I've talked to former prison officials, superintendents, they support this bill because they say it incentivizes people coming in, especially young people. You give a young person 50 to life, they just think my life is over. Why am I going to do these programs? Why am I going to change my way of thinking and acting? For what reason? But if they know that, hey, wait a minute, yeah, you got 50 to life, but you have an opportunity. Get on the right path, do what's expected, and maybe you won't be in here for the rest of your life. So I think there are a lot of reasons and there are a lot of different organizations and levels of support for a second look bill.
So that's kind of percolating. And one of the interesting things about that bill is that it provides the judge with the opportunity to review a sentence, not a parole board. So, you've talked about sort of trying to give people second looks by accessing the courts. I also know that you've done some work trying to give people a second look by accessing or by supporting them in their parole process. Could you tell me a little bit about that?
Sure. There are two different ways that we've approached the parole process. This is something I probably should have mentioned up front. Clemency, from my perspective, I just want to go back to clemency and then I'll get to parole. Where clemency really is most needed is for the people, and this is not hyperbole, who are serving death by incarceration sentences. So in other words, 50 to life.
Just so that people understand, there are certain sentences that just don't provide the opportunity to go before a parole board. So if you're sentenced to a specific kind of sentence, there's no chance to have your sentence reviewed. And I think that's what you're talking about here, Steve, right?
Exactly. I used to joke that this is my Thanksgiving conversation with family. I hear people saying, 50 to life, what, you get out in 20 years? And I know there are some states where the sentence isn't actually what someone might serve. New York State, we are a truth in sentencing state. In other words, we get federal money. So 50 to life means you are going to do 50 years. That's when you'll see the parole board, not 30, not 35, not 40. So for me, we usually focus on people who, but for clemency, are likely to die in prison. And so when I would get letters from people saying, I've been denied parole 3, 4, 5 times, can you all help me in your second look project? I would write back and say, look, my heart goes out to you, but we really work with people who have no shot. You got 25 to life. You've been in 35 years, but you see the parole board. You have that opportunity. But more and more people were writing saying, yeah, I have that opportunity, but I've been denied 7, 8, 9, 10, 11, 12 times. And I thought to myself, on what basis? So then it opens up your mind to the tragedy of the parole process. And this came up with Judy Clark as well. And that's what led me into parole work eventually. Judy came before the parole board. They interviewed her for a long time, of course, and most people know this. They weren't that interested in what she had done over 34 years inside. All they wanted to talk about was the crime. Why'd you do this? Couldn't you have done that? What were you thinking then? Et cetera, et cetera. And so when the decision came out, a very brief decision, and it said basically, and I'm paraphrasing, but this is basically it, due to the serious nature of the crime, parole is denied. And here's where I just have to confess. The first time I read that, I thought, I get it. Yeah, it was a serious crime. 2 police officers and a third person were killed. But it was actually Judy who educated me because she said, well, Steve, they gave me another date in 2 years. And I said, right. She said, but why bother? And I said, what do you mean, why bother? She said, well, if they can deny me because the crime was serious, the crime is serious. It was serious. It's going to be serious in 2 years. It never becomes not serious. And that just, when you explain that to people, and when she explained it to me, it shows you the problem with parole. You can't change that. So if parole boards want to focus on the crime and they can deny you based primarily on the crime, what's the point? So that's where we've been helping people, and we're trying to change with advocates, the Parole Preparation Project, release aging people in prison, so many organizations in New York, trying to have both legislative change to change the parole standard, but also just through advocacy to try and force the parole board to focus more on who the person has become. What have they done inside? And so we help people prepare. We put together advocacy packets. We move the interview so they can do everything possible to try and force the board to do what it's supposed to do, which is evaluate them today. So that's the front end on parole.
Yeah, I mean, parole, if it's a static evaluation of the crime, nothing can ever change about that. I mean, and again, that's not to negate any harm caused. It just means if we are serious about parole processes as a second chance, then we've got to be serious about looking at the person and who they've become. So that's amazing that you help people get ready for parole. And with the clemency power, so you had success in Judy Clark's case. I know you've done a lot of clemency applications. Can you tell us a little bit about Bruce Bryant? And I understand that he was incarcerated under Bruce Bryant with a T, but that was not even his real name. So tell us what happened with him and the work that you did.
Yeah, Bruce's case, it's somewhat unique. And let me explain why. Bruce is someone who is wrongly convicted. He still has his wrongful conviction claim pending in front of the Queens County District Attorney's Office. And lawyers from the Legal Aid Wrongful Conviction Unit have embraced the case. So to me, the evidence is overwhelming that Bruce did not commit the crime. Of the 55 people who received clemency, who had their sentences commuted, the core of their application was innocence. But that's rare. I just want to emphasize that, because from the governor's clemency team, if you're claiming innocence, their response, it's not to say we don't care. Typically, they'll say, well, you should go to the DA's office that does conviction review, go into court, because they will examine it and investigate it in ways we don't have the power. But in Bruce's case, my position with the governor's people was, look, here's the evidence that Bruce is innocent. And I know that you can't fully investigate it. You don't have that kind of staff to go interview witnesses. But here's the thing to keep in mind. Even if Bruce were guilty, he merits clemency on every conceivable measure. The way he's lived inside, the people he's mentored, the programs he's developed, the programs he's facilitated, the support he had inside and outside. Bruce's clemency packet was 499 pages. We could have gone more. There were so many people writing support, currently incarcerated people, formerly incarcerated people, people who worked in the prison, people who'd come into contact with him in a variety of ways. That's the sort of person that Bruce was. So to me, it was, I hope I don't have to persuade you, meaning you in the governor's office, that he didn't do it. I think I can do that if you give me the chance. But beyond that, this is someone who, if given the opportunity, is going to do great things on the outside, which is also true. Bruce now works at the Queens Defenders, a public defender office in New York City, working with lawyers, working as an advocate in a variety of ways, and is just a force for good and a force for change. So Bruce is a shining example of what clemency is about, frankly.
Yeah, that's amazing. Now, we've been talking about all these different things, compassionate release not working so well. Maybe you could say a few words about that.
So the first client that we had, when we started, actually, this was someone who was close to 70, had been in about 40 years. And his health was not great, but it was rapidly deteriorating. So I then discovered there was medical parole. And I really want to be clear, this is not me patting myself on the back. When I say these were underutilized, here's the larger problem. We don't have any organization that is devoted to this back end work. So this is my elevator pitch when I go to people saying, you ought to do this. I was saying this before, you get these letters when someone writes and says, I'm innocent, I refer them to the Innocence Project. And there are never enough, but there are plenty. If someone says my lawyer was ineffective, they didn't call my alibi witness, I refer them to every appellate office I can find. But when someone says, I'm doing 50 to life, I need help with clemency, there's nowhere to refer them. We're the only organization in New York that does this 24/7. And we're barely making a dent because we're a tiny outfit. Similarly, if somebody writes and says, hey, my partner, my husband, my son is dying in prison, can you help with medical parole? There's nobody doing that either. So when I foiled the data on medical parole in New York, there's virtually no application submitted and it's virtually never granted. So there are all these avenues that we just have to figure out how to, whether it's funding, whether it's attention devoted to them. If ever that ridiculous phrase, we put people in prison, throw away the key, that's really what this is about. It's like, we don't care that you're dying. We don't care that you've changed. We don't care that parole is only focused on the crime of conviction. And, if there were more organizations, whether legal organizations or advocacy organizations focused on this 24/7, I think there's an opportunity to make a bigger impact. So medical parole, New York, we actually have one of the better statutes. It's sort of like the DVSJA, the Domestic Violence Survivors Justice Act you referenced. We have a statute. It's just being so narrowly applied. So you have to be terminal. Okay, that's fine. That's like most compassionate release statutes. But we also have another section in New York, which says if someone is unable to take care of the daily activities of living, clothe themselves, bathe, eat, walk around, they should be considered for medical parole. And so early on, I went about this the wrong way. I just wrote letters saying, hey, this client of mine, I have his medical records from you all, from DOCS, the Department of Corrections. Look how sick he is. Please give him medical parole. And I'd get a 1-paragraph template denial. It was the same denial for everybody we submitted. And that made us realize, okay, we have to make this harder for them. So we began to reach out to doctors, get our own independent prognosis and diagnosis. And it's a wonderful organization called the Medical Justice Alliance, where doctors will do this work. They reach out to doctors interested in social justice. So it makes it harder for the Department of Corrections to deny an application when you have a licensed, certified doctor who reviewed the medical records saying, these are the reasons I think they qualify.
I mean, just to be clear, Steve, in New York, there are some facilities now that have dementia units. Like I think Fishkill has a dementia unit because they're people who have aged in prison and no longer are fully operational on that front. And they're certainly not able to engage in the functions of everyday living.
It would be funny if it wasn't so ridiculous. One of the first people where we were successful in getting medical parole was suffering from dementia. It started as physical ailments, but over the course of several months, he had the onset of Alzheimer's. What I learned then is you apply in New York for medical parole. And when you get a letter saying you qualify, I thought that meant someone was being released. All it meant is now you're going to get an interview. I thought to myself, you're interviewing someone who has Alzheimer's. I don't have the adjective. And mercifully, he was granted release and he had family who could take him. But I do want to say one other thing. I do appreciate the challenges with compassionate release and medical parole when it comes to where is somebody going. Because we're submitting applications for medical parole for people who've been in 30, 35, 40 years, have obviously very serious medical issues. Where are they going to go? Family has passed. Do they have somewhere to go? And then you reach out to every organization and they go, we don't have beds. We don't have space. It's tragic.
Yeah, the whole thing is so complex, right? I mean, it's on the one hand, you don't want to just keep somebody incarcerated because they don't have an alternative place to go. And yet there's something cruel about releasing somebody who doesn't have a place to go. And I know with medical parole, there's often a requirement that there's a plan in place. Now, we've been talking about all the ways that you have been able to help people. How many people would you say you've served, Steve?
About 175 we've represented.
That's a lot of people for such a small organization, too. I mean, that's terrific. But are there people who you've really thought are just so deserving of a second chance that you just couldn't figure out a way to get in front of somebody to review their sentence?
The challenge with the work that we do, and this is such a hard conversation, there's this notion of exceptionalism, which pulls and repels at the same time. So after Judy Clark, one of the first persons we worked with who got clemency was a man who was about to become the first New York State prisoner to earn a PhD inside. You talk about setting the bar very high. The governor's people received his 400-page dissertation. And they said, who is this person? He, 2 masters. I mean, he was teaching classes. And I was thrilled for him, still am. went on to actually teach an undergraduate class at Yale. I mean, pretty extraordinary. But the thing about it is, did you just set the bar so high? And so when people write to me and they say, I've earned a degree, I've done this, I've done that, naturally you think, oh, this is a great case for clemency or for some kind of a second look. But what it does for me, and I have to recognize that often I feel like I'm feeding into this, it obscures the larger issue, which is the massive sentences. So when you ask me, are there a bunch of people that I can't figure out how to help? Sure. I'm thinking of people we're working with right now. We're struggling with this. There's a man who's doing 35 to life for a robbery where nobody got hurt. He's 61 years old, a lot of challenges growing up, been arrested multiple times. You know, he's putting one foot in front of the other as best he can, but he's not someone who's going to get college degrees. He's not someone who the superintendent knows because he's facilitating programs. So what do you do about that? What do you do about him? Again, that gets to the question, the motivation. The first thing you asked me, why get involved in this work? It's because we sentence people to these terms that are unknown and, in my view, unjustifiable. And they're particularly unjustifiable because we don't have a built-in second look mechanism, right? So the sentence gets imposed. I have read so many sentencing transcripts, and this is to people in the judiciary, the amount of hubris. Hubris is a nice way of putting it. I think it's a lack of humanity. I have read so many sentencing transcripts where judges say, it's clear to me you will forever be a threat to society. How do you know? And in fact, now I'm looking at someone 20, 30 years later, and they have all the support, sometimes from the victim's family. And yet there's nothing to do because the judge made this kind of pronouncement and gave them a sentence that foreclosed any chance of them ever walking free. So yes, there are people you just struggle trying to find that potential pathway. Absolutely.
You talk about the exceptionalism, right? The someone who's just so remarkable that to keep them incarcerated for another minute just seems contrary to all common sense. And yet, for the common person, for the average Joe, what was exceptional was the sentence imposed, right? 35 years to life for a robbery where no one was hurt? Why is that okay? Why is that not the exceptional piece of the story? And so I so appreciate what you're saying because that does get a little bit lost. And to your sort of larger point, most of the folks who commit really serious crimes themselves at one time were victims of serious crimes or grew up in an environment of trauma or whatever else impacted their decision making along the way. So it's all so complex. And I'm just wondering, what do you think is going to happen in New York in the second chance landscape? And if you had to make an elevator pitch for what should be happening, what would you say, Steve?
First of all, people say to me sometimes, I'm not trying to avoid the question, but they say, if we got a second look bill, then we wouldn't have to invest so much time in clemency. And I say, no, because we're looking at different pathways. Where is the lever to freedom? So you have the governor on the one hand,